Hi, my name is John Olegas, and we're going to be talking about how my children were kidnapped by officials from the Marin District Attorney's Office, and my constitutional rights and their constitutional rights were violated, and crimes were committed under Title 18, Section 242. But what we're looking at right now is an order from head judge Verna A. Adams, who's now the head judge, issued on July 21st, 2003, and filed one day later. It's an order to me to appear in court pursuant to an application by DDA Leon Kusharian, whereby he attached a declaration from Patricia Stafford, an investigator for the Marin District Attorney's Office. His application and her declaration were both under the penalty of perjury. They essentially made three allegations to support their petition for this order. One was that my ex-wife had sole custody of our children. Two, I unlawfully took the children out of California. Three, I was a fugitive having fled the state of California, and they found me in Louisiana after I had allegedly committed a crime in California. So they went ahead and got Verna Adams to issue this order to bring the children back for further custody hearings. And in fact, on page 2, she makes this temporary order whereby Patricia Stafford of the Marin District Attorney's Office, Marin County District Attorney's Office, will have the temporary physical custody, care, and control of the minor children of the parties. So she thinks she's got jurisdiction to order my children back to California for further custody hearings. All right, so we're just going to go skip to page 3 and see that where there's this attachment to the temporary order. And so this one was issued on July 21st, 2003 also. And it has to do with an elaboration of the other order where she says that Verna Adams signed this and perhaps wrote it in herself, where temporary custody is going to Patricia Stafford and that the children should be brought back to the court pending further hearings, pending further custody hearings, pending further custody orders and hearings. All right, so they're saying, go get the kids. Mr. Olegas, who's their father, unlawfully took them out of California. His ex-wife has sole custody, and that he's a fugitive, and that we, under the laws of the state of California, have the right to issue this order. Now, we're going to go back to another element of the page 2. Right here, it says 3D1, it talks about the jurisdiction. It says the court has jurisdiction to make child custody orders in this case under the Uniform Child Custody Jurisdiction and Enforcement Act. 3D2 says notice and opportunity to be heard. The responding party, which is yours truly, John Olegas, was given notice and an opportunity to be heard as provided by the laws of the state of California. So this is a form, and she signed it, and the language is in the form, and the reason the language is in the form is that she's not supposed to issue orders like this unless her court has jurisdiction to make child custody orders, and that I have prior been given notice and an opportunity to be heard. So that's what it says. She signed it. She didn't black that out, because she can't black that out, otherwise it's inconsistent with the law. But the fact is, I never had notice and hearing, and it was subsequently ruled by Judge Vernon Smith that she didn't have jurisdiction to issue the orders because she didn't have jurisdiction to make custody orders. And the reason Judge Smith agreed with that is because my ex-wife, Peggy Bennington, told her that in open court. and Mr. Kusharian agreed. So it's been proven that this was fraudulent. Okay? Now, what is the consequences of doing this? They allege that I had notice and hearing when I didn't. Well, it's a violation of my constitutional rights. Let's see what the Ninth Circuit Court of Appeals says about it, what they did. The Ninth Circuit Court of Appeals says in 1993 it was clear that a parent had a constitutional protected right to the care and custody of his children and could not be summarily deprived of that custody without notice and hearing, except when the children were in imminent danger. Quoting Caldwell versus the Fever. All right? And then later on they said pre-existing law requires Kamahili and Silver, the people who abducted Ram's child, under the color of law. The Ninth Circuit says that they were clearly required to provide Ram with notice and hearing before they interfere with his custodial rights, quoting the Supreme Court. To terminate parental rights, state must conduct a hearing under a constitutionally proper standard. The exception to this norm applies only if Ram's children were in imminent danger of harm. They seized my children without a hearing, without notice, and they never alleged any harm, because there never were any harm to the children. So they violated my constitutional rights. And that's the Ninth Circuit, and there are the Seventh Circuit and the Fourth Circuit say exactly the same thing, that they can't do that, and it's a violation of your constitutional rights. If they do it, they're committing a felony under Title 18, Section 242. The statute makes it a crime for any person acting under the color of law to willfully deprive or cause to be deprived from any person those rights, privileges, or immunities secured by the Constitution and the laws of the United States. And the maximum punishment is life imprisonment or death if the acts include kidnapping or an attempt to kidnap. That's what they did. They should be brought to justice, and I will have more of these shortly, so stay tuned because it's a long story.